disposed of only on the ground that the readable is pending.
Next week we can.
Matrimonial appeals. There are displacement. Only one defect within the premises order. So, madam, let it come next week for orders.
A week after next week, have it.
Due to the pendency of the appeal filed by the state, the petitioner who has retired since 2021 is not getting a single pay towards pension.
He has retired in 21.
21.
After 2 weeks, give some date. Right? Distribute it. Clustering should not happen.
Regarding the appointment, because the present will suspend the honorable single judge.
When?
In 2024.
24? In the second week of August. Okay.
For fresh read of new rules. Fresh read of new rules.
Fresh writ appeal. In the first week of August. Okay.
Lots of may I mention?
Yes.
So last week, lots of mentioned for new writ appeals to be taken up today, lots of. So unfortunately, it is not listed.
Not listed.
Not listed.
Why that it is not listed?
And it's a very short matter covered by 2 Supreme judgments, lots of.
So we'll post them.
This highly recommended for more, lots of.
Tomorrow it's
It's a very short matter, 2 judgments of the Supreme Court governing the issue.
yes. Go on.
Public.
Yes. Yes. Yes, well.
Appearing on behalf of SKN, I kindly urging this item number 7.
Item number 7. 1 to 10 we will not consider. 1 to 10 you have to wait. Yes.
Grade 3, grade 23, grade 4, 22, 31, grade 5, 32, 34.
Yes.
Formula.
The justified order dated 16/5/25 17 specially issued to the opinion number 3 with the contesting opposite party. But tracking has not been revealingly
Service incident reflected.
reflected.
Service on whom?
Opinion number 3 with the contesting the registered pharmacy council.
Pharmacy council, man.
Who appears for pharmacy council? Any standing council is?
No.
No standing council. You are for
Board. For board and the board.
You are for the appellant.
I am for the petition.
Petitioner. Sir, what?
Instructions on the
As to whether you can obtain a postal track record, na?
The office is to be
Kindly look at, Mr. Kindly look at this paper list. It is available for you. So when it reaches you, because the order has to be passed, we are not pulling out a file.
Yes.
Therefore, kindly wait. Just in the meanwhile, you verify. All. No system itself.
My lord, 39. I want to file in the counter in this case. So I have taken consent of the petitioner council. Counter has to be filed 2 weeks time maybe.
Serial number?
39.
39. Of which year? 24.
24.
You want to file counter? Yes, ma'am. For filing counter, a period of 2 weeks is granted. Filing which content. First up, if counter is not filed accordingly, the right to file one stands forfeited, and petition averments may be taken up with face value. Okay. Taken with face value.
There is a typographical mistake.
It should not be put as effective.
So, sir, there is a typographical mistake. Registry has pointed out that inadvertent typographical mistake has crept in order number 5, dated 12/5/2025. The adjournment date has been inadvertently typed as quote, list on 27th March 2025. After today's listing, the said the said date stands corrected. It should be 27th. Already over. Corrected. Corrected for the purpose of records. For the purpose of records.
None.
Two weeks after, Mr. Mishra, he has some personal difficulties, your lordships.
2 weeks after it.
Gratefully, lords.
Please inform your friend. He's on record.
I don't think
Develop it.
my lord, appearing on behalf of Mr. S.K. Naik, we adjourn this meeting.
You want time?
Adjourn this meeting.
Adjournment. You don't want time. Same order.
Oh, sorry, my lord.
Rather. You want adjournment, na? Yeah, we are granting it. Yes. Unless you say you object to that. Yes. 3 weeks. Can we make it 3 weeks, brother?
Yes. Please be attentive. Don't nervous. Don't be nervous.
Fresher? Are you a fresher? Yes. Come in the front. Which college you are from?
MS.
MS.
Boston Law College.
Best college. Which best book you have read on law or on jurisprudence? All right. Which book you read on jurisprudence?
Allah series.
Allahabad series. How? This is not a happy thing. Jabwala series. Very difficult. You should read good books. It's not very good books. So Bhagavad Gita says, Nahi gnanena sadrusham pavitrameha vidyat. Knowledge. If you get the bad books, whatever knowledge you have, that also gets polluted. Therefore, read good books. All right. Next time when you come here, I will ask you. I remember your face. All right. Or which book will read? Salmon's jurisprudence, Peyton's jurisprudence. All right. Anybody will tell you. Your friends, your brother will say that. Yes. Julius Stone, Lloyd, many books are there. Read just this. Okay.
Yes, sir. Lordship, in fact, Lordship, I want to.
We have not seen you for quite long period.
Sorry, Lordship, I am.
Very right. Yes, now you are here. Let us celebrate it.
Grateful, Lordship.
Yes.
Lordship, in fact, Lordship, I have gone for judgment, recent judgment, but it is not uploaded. Regarding Lordship, here, Lordship, a student has completed his medical course.
What is your complaint in this? We don't remember.
Lordship, no, for first time it has come, Lordship. And Lordship, I have completed the medical course, MBBS course. Because I have not paid, Lordship, due to some financial crisis, they are not allowing for internship. And Lordship, they are not, Lordship, giving the.
You came running.
Catch your breath.
No, Lordship.
After Passover, at least for 5 minutes, let us continue.
Sit down. Very interesting. There's no reason to be that anxious.
Lordship, grateful.
Yeah, Passover.
Item 11.
Formal and notice has to be. This will be through local police.
Local police.
Yes.
Issue fresh.
This is Kongamali.
Yeah.
39 opposite party. Government has filed a list of opinion with 18 days delay.
85 days.
Matters have been heard. You have put it all these matters on particular yesterday you spent and published.
That matter, that notes was.
2 weeks after.
2 weeks after.
2 weeks after.
2 weeks.
Your matters have already appeared.
They have already appeared.
Can you assist us that whether very different from that of the
Delay state government delay for it.
What are the parameters for consideration when state seeks the leave to appeal?
No, limitation provision manner, I will leave to appeal manner. There is a sufficient ground to delay condone the delay manner. In this case manner, government file a limitation provision manner, there is no.
What is the delay?
Delay manner 81 days delay manner.
200.
81.
821. 821.
81.
81 days.
81.
What is this? 81 days. Application is filed. Second. The petition is accompanied by an application for condonation of delay and it is supported by affidavit. First up, delay just being 81 days is too short to be little. First up, no prejudice should be caused to the other side by condoning the delay, since the matter would be taken up on merits. First up, in non-condoning would result into prejudice to the public interest. First up, in the above circumstances, application is favored and delay is controlled. Yes. Now petition for leave. Leave. What is the offense? What are the offenses?
Offenses of 20B, 2C of the NDPS Act.
20B.
20B and 2C. And
What is the punishment?
Seizure is my lord 103 kg.
Punishment.
10 years.
10 years. Yes, so we will also
Reported as 85 days, in fact. Delay is not properly explained, madam.
NDPS is a parliamentary legislation enacted pursuant to international convention. Therefore, India owes an obligation to the world at large that we will do all these things to eradicate the menace. It's a serious issue. Lives of many students are being ruined because of drugs.
2016 judgment. Head government has not properly explained the delay.
We have gone to the next level. We have crossed the bridge now.
Leave is granted, that is the appeal.
So leave needs to be granted.
Prepare on merits.
But right. State seeks leave to file this appeal in as much as the respondent has been acquitted of the offences punishable under the provisions of NDPS Act. First up, NDPS Act is a piece of parliamentary legislation enacted to give effect to international conventions to which India is a signatory, party and signatory. First up, under Article 51 or 52, which is that article?
52.
Under Article 52. Under Article 52, in terms of case one on the Bharati versus State of Kerala, 73 Supreme Court so and so, it is held that international conventions partake the domestic law, character of domestic law, if they are otherwise not inconsistent with it. And that court should keep the same in mind while interpreting legislations made for giving effect to such international conventions. First of all, same is elaborated in Jolly George versus 51 it is, Article 51 of the Constitution. Same is elaborated by Justice KRISHNA here in Jolly George Varghese versus Bank of Cochin. You said Cochin. Bank of Cochin. Cochin. 80 Supreme Court. 1980 Supreme Court. First up, the punishment prescribed for the subject offences is 10-year imprisonment and fine It is and fine.
Yes, please.
Or fine or end fine. What is that?
And
And fine. And fine. First one. Public at large is interested in the administration of criminal justice. Justice. First. Next paragraph. In the above circumstances, leave as sought for is accorded to the state. State. First. What is the next stage here in your state?
So it's to convert it into government. It's to convert next stage.
Convert it to the government appeal.
Government appeal the
Conversion of the matter as a government appeal.
government.
And bailable warrant.
And
Bailable warrant surrender before the lower court.
and bailable the trial court is directed to issue bailable warrant to the accused. To the accused. All.
Change of nomenclature is the government.
It's government appeal.
Since if you want,
You can application for appear bail or receive. You have to make application.
you know the next step, you have to file an IA. IA or here.
Yeah. You have separate set of criminal rules of practice for the state. High Court rules only will cover them. Okay. Just look into them. I'll also look into it. So don't know. They are a bit different from Karnataka state.
We are not acquitted. Convicted of the sentence, then arrested now.
Therefore, we granted
7 months.
Yes, you're all right now. Yes. What is the point in what? Not able to pay.
Yes, Lordship. Page 26, Lordship. Since last 15 months, Lordship.
Wait 1 second.
Lordship.
You are not able to pay.
Exactly, Lordship. I daughter of a senior practitioner of this member of this bar, Lordship. In fact, Lordship, I want to pay, Lordship. I'm ready to pay. But
They are not accepting because it is delayed.
not delay, Lordship. Because I want in a
Installment basis.
Lordship, because no bank is granting me loan, Lordship. And
In a similar circumstance,
Yes.
how various high courts in the country have treated the matter?
Lordship, I have given number of judgments, Lordship.
You-
Yes, Lordship. In fact, Lordship, I want to make the state party. I have done mistake, Lordship.
You make the state party then.
State party, Lordship. State, because this particular institution is getting benefits from the state, Lordship.
A state aided.
State, not but Lordship, now he has this some hospital, this institution has taken some hospitals.
Taking the state better.
Not
Purely
state
private.
No.
Purely private.
I'm not saying that.
Yes.
I'm saying this institution getting benefits from the state.
And that
You have
is
given-
different.
Yes.
What is that benefit? Land? What?
Yes, Lordship, land, they have done land and Lordship, other financial benefits.
But for that you have to make an application. Huh? It is your oral submission. Maybe that you have taken around
I have
warning.
I have taken this step, but I have not met state party. State to answer
To
also.
make a party,
Lordship.
you have to make an application
Yes.
under Order 1 Rule 10 read with Article 226.
Lordship.
Is it?
Yes.
You make that application, we consider. When you want to file that application?
In fact, Lordship, what I pray, Lordship, let it come tomorrow. I'm just going to give an amendment application. I'll add the state party.
Call this matter tomorrow.
Lordship.
To enable counsel for the petitioner to take steps for arraying the state as one of the respondents. Respondent.
And in advance, I can serve copy to my Lordship, senior Lordship, which appeal for other opposite parties. I can serve copy, Lordship.
Very well. You serve a copy in the meanwhile.
Lordship.
A copy of the petition along with all the documents be served on the learned senior panel counsel, Shri.
or National Medical Commission.
National Medical Council, the separate standing council appointed, Mr. K.K. Satpathy. OPID 4. Apparently, we are for OPID number 1 to 3.
Union opinion 1 to 3, Lordship, my friend senior is saying, but my senior is from opinion number 4.
He says the same.
OPID number 4, the knowledge is Tushar Satpathy is appointed as a standing council for medical council.
No.
Notification came into force.
To resolve the dispute between.
I don't know. Let them serve. Let them appear. I don't know. Let them. But I know. I just enlightened the court. If he is authorized to appear, let them appear. I don't have any objection.
He wants to appear.
Yes, ma'am.
Yes, let them appear.
Shri, and so volunteers to appear for the MCI.
NMC, my lord.
NMC. First up, petitioner to serve copies of all the readings and documents on the learned advocates representing the parties. First up, call tomorrow. Grateful, Lordship. You have to bring how various high courts have treated.
Lordship. Lordship.
Okay.
Lordship.
In the meanwhile, read Jolly George also. Read Jolly George also. Okay.
No, it's a judgment, Lordship, the Supreme Court has given.
We do not know. You have to bring it. You cannot say orally. Yes. Yes. We can say, as judges, we can say that there is a judgment like this, etc. You can't say there is a judgment and you should presume that there is such a judgment. That's the difference.
But some reason that is yet to be uploaded. This is judgment. That can help me, Lordship. That I'm saying.
Then we will have it after that judgment is uploaded.
Lordship, if it will monitor, then Lordship said if I will take special notice on OP number 5 and 6, then it will suffice, Lordship. It will come on Monday. I'll take notice special on 5 and 6.
No, issue notice to OP numbers 5 and 6.
Special messenger. Bhubaneswar, it is Bhubaneswar.
Huh?
It is Bhubaneswar, Lord, special messenger.
By special messenger.
Special messenger.
By special messenger. First, requisites to be complied immediately. First, post immediately after service. After service.
Lordship, 7th, Lordship, because last 15 months, 7th, Lordship.
Post this matter on 7th. If service is accomplished.
Lordship,
Item 40. Informant seeking for a leave to file appeal matter, challenging the order of protection to the past of the London penalty.
What is the offense?
Offense 373. But an inadvertent mistake is there, that I will have to file an appeal instead of filing the CRLE. Because 2008 amendment says that the liberty is granted to the informant to directly file lordship. To directly file appeal before the court challenging the judgment, challenging the order of acquittal passed by the London trial.
No, 9 years have lapsed. This what we should do.
That I want to file an interim IA for change of the nomenclature from CRLLP to CRLM.
Is it permissible? From appeal to revision is permissible. There are judgments.
No, that's just the 370.
From revision to
372 CRPC, my lord. This is granted that informant has got right to file appeal, directly file appeal before.
We are not on that. We are not on that. Question is, can a revision be converted into an appeal? There are judgments which say appeal can be converted into a revision.
No, judgment is there. If lordship grant me that the liberty to file a fresh application that
this will dispose of them.
Lordship will dispose of only with the liberty to file criminal appeal.
KRISHNA, this next. The criminal leave petition has been filed, seeking leave of the court to file the appeal. When such a leave was uncalled for, inasmuch as liberty is reserved to the petitioner hearing to file the appeal directly, and therefore he be permitted to withdraw the petition with such liberty. First, state is not a party.
Yes, state is
a party. Do you have objection to that?
No.
Have you filed a appeal?
No. That's not. Yes. Notified.
The immediate public prosecutor is that state has not filed the appeal. And that we have no objection for granting you to withdraw the petition with liberty to the petitioner to file appeal if we so choose. First, next one. In view of the above, the request for grant of leave is granted and petition is before all that having been withdrawn with liberty to file appeal. It hardly needs to be stated that the period spent during the pendency of these petitions is liable to be discounted while computing the period of limitation on such a period in terms of rule or akin to rule, akin to rule enacted in Section 14 of the Limitation Act 19.
2022, it's matter relating to the recovery of 2022, it's matter relating to the recovery of excess amount from the employee. In fact, Miller's topic must. Yes.
Howard, what is the designation of the employee?
It's a Miller's NMR employee and brought over the work charge establishment.
Then passive paragraph 5.
18. 18 has principle laid down.
No, your is
Yes.
I'm reading C. No. That you don't have any case here.
Recent decision also against me. That is, I have given that recent decision.
This infra court that we seeks to lay charge to a permanent single judges genuine cases.
Order. It's a consent order.
It's a consent order, and moreover, it's a part of the patch case. And similar cases have been disposed of.
Whereby you are in fiction.
And the petitioner.
Respondents WB number.
The Lordship recent
laws. Principally, on the consensual stand taken by the parties. Permanent consent by the permanent AG, appearing for acceptance of which that there is an appealable case in this appeal, and therefore appeal to heard on merits. Permanent counsel appearing for the respondent was the writ petitioner opposes the appeal, contending that on consensual orders, right of appeal does not avail in terms of Article 43, that rule no appeal against consent orders.
Order 40.
Rule 43, so and so.
Rule 10.
Which are will be applicable to these proceedings as well.
Order 47. Order 41, Rule 3 or 4. I'll check it up. Head of Phil Lights.
Next,
43 order from.
Even otherwise, case of the appellant is covered by the affix good decision Pratik Masi versus
State of Punjab. State of Punjab. 80. 2015.
Fine.
I've given them.
No culpable act is likely to be true by the qualification. We are broadly agreeing with the submission of tribunals and other respondent. Because it hardly used to be stated that ordinarily in most of the rights against consent order, wishing to show the heads of the officers, notwithstanding, in the person, yes, that was a consistency. Face. Cost means.
There is also a delay of 410 days.
That's why I'm saying so. That is gone. 2015 4 SEC 334.
SEC
334.
334.
Yes.
Yes. Modification, linguistic modification.
But entire judgment is against me. So that's.
Indian Melod's intra-court appeal. It stated that matter was heard another matter. By virtue of the same, on the ground of limitation, this was dismissed. Reject. That judgment I have given yesterday also. I'm also giving the.
Yeah, you have given, but
posted to 8th.
There where we cost of 5,000.
5,000.
Our court officer is very efficient, I tell you. He read a particular paragraph in that judgment. Can you see that? He pointed out that yesterday. Our court officer pointed out when already delay is controlled by the highest court of the country. This court will control again. But in the meanwhile, we had signed on. When you read para 3 or para 2, para 3. Read that.
In matter like this ordinary delay.
Appeal.
3 and 4.
Appeal itself, not application for condonation of delay. Therefore, there is a deemed condonation. What is it?
It's an option. Will I accept? 3 and 4 is very clear. That is.
So we'll say that need not that there is no close application. This appeal is filed after booking a delay of
129 days.
129 days.
Right on this thing. We'll say some, so because arguably that this side, that side, because already we have taken a view now. In that yesterday we have taken the view after interpreting this judgment. Is it not? Though we'll say that application is allowed, a delay is condoned. But appeal is filed after booking a delay of
129 days.
120 days. First of an application supported by the affidavit accompanies the appeal seeking condonation thereof. First of. Learned AGA is right in telling us that in identical matter, the apex court sent the matter back when a coordinate bench of this court had negatived the appeal of the kind. And therefore, the same approach needs to be had to this matter as well. First of all, in all fairness, learned counsel appearing for the respondent agrees with this submission. First of all, we have also noted the contents of apex court order in civil appeal number.
Please special leave to appeal number.
SLP number
26359.
26359 of 2023 between State of Odisha versus Atal Bihari Mohanty. Atala Bihari Mohanty. Atal Mohanty. Disposed of on 11/11/2024. First, next part. In the above circumstances, we formally allow the application and condone the delay. Appeal to be taken up along with that matter, we will take this matter. This also.
One small thing.
129.
The yesterday matter was Badrinarayan Rautre.
Call this the matter along with the writ appeal number. On the day, on which date?
116 of 2020.
Call this matter on the day when substantially similar matter in writ appeal number
116 of 2023.
2023 is posted. Okay. We'll not say call along with. We'll say that when it is posted, let this be posted.
One small your lordship. And the high filed by the state for dispensing with filing a certified copy of the impugned judgment.
Other copy you have.
Dispensing of original records are with the court. Usually intra-court appeals, it's not required. So that's the purpose.
Whether the online copy you have filed, order copies. You have here filed
certified copy. For that I have filed this.
That's all right, because the limitation itself.
They have a certified copy along with the appeal. That filing I have got to notice.
Filing of certified copy of the judgment, impugned judgment is dispensed with. Since the copy filed is not, the authenticity of the copy filed is not disputed. What is that after all? Yes. Yes, next.
Item 18.
18.
Lordship, I'm appealing on behalf of the cabinet commission.
Your cavator.
Yes, Your Lordship. Appeal has been preferred by the state, Your Lordship. Union of India.
Who appears for the union? More often than not, union is a destitute one way. Some cause here. Yes, you want? Yes.
My lord, I'm sorry, my lord.
All right.
I'm seeking some time because the counsel who's earlier appearing, she is joined in the state penal. I got the file, let me give the next week.
Have you got copy of the appeal memo?
No, Your Lordship.
You don't have?
We'll serve. Yes, we'll serve. By tomorrow, we'll serve. Yes.
When do you want?
Next week, any day. After 10 days, any day.
Call after 2 weeks.
Lordship, I really pray that a short date may be fixed because
Why you are cavator? How can cavator ask for a shorter date? No order is passed against you. Yes.
Item
19.
For the cavator petitioner copy is
Copy is not given to you.
No.
Yeah, notice is ordered already.
On the last occasion, the bill has been condoned.
Condoned? Yes,
26/2/24. 6/2/24. 6/12/2023. I agree.
In course of your service.
You serve a copy on your friend.
By tomorrow, I am serving.
All right. Call after 2 weeks. Okay. At the request of learned AG. Yes.
Item 14.
Fiction Act. None appears for the appellant. Call week after next to enable him to enable counsel to come and argue for the appellant.
And this report of email. The order dated ballot, then days of the vote because it is passed by the unvoted single judge in order challenge ballot. Then this matter relates to appointment under rehabilitation assistance scheme. And the date of the district government servant.
You have the microphone there. Just put it on your desk. This microphone.
Directed the respondent to present appellant ballot to consider the case in view of the.
Your case and your voice both are weak. Your case and your voice both are weak.
I'm sorry, madam. The honorable single judge ballot.
Put on the mic. Drag that mic.
Single judge ballot.
Yeah.
Directed the present state respondent to consider the case of the present respondent ballot
For
in view of the
consider for what?
for appointment under rehabilitation assistance scheme ballot.
For appointment under rehabilitation scheme.
Ballot.
What is that scheme about?
Ballot,
Can anybody explain? Yes, brother.
It was earlier it was 90 and the amended provision is of 2020.
Which learned senior Doka is referring to other day.
25.
Exactly.
Amended in 25. That is.
Amended in recently
2016.
We have passed all
25
orders.
25.
So you produce those orders where we have considered and yes.
Rule 6 surplus 9 has been subsequently amended.
Amended.
Pending cases of the 90, it will not be guided by 2020, rather it will be on 90.
From the date of
We disposed of some matters on this basis, na?
That gadget was supplied on the other day.
Other day.
from date of the death of
Can we
the
show the order we have passed?
Other day, who appeared? You appeared in that matter, in those matters.
Mr. Ponda, Mr. Ponda.
Honda appeared. Correct, you are right. Do you have a copy of that order? Then we will, in terms of that, we will dispose of this one. Huh?
Passover.
You are appearing, but you are given benefit under the amended rules. Therefore, appeal is meaningless now. We'll make that order.
Series of matters has been disposed of by the Honorable Apex Court in keeping in view that newly amendment of
The subject matter of this appeal by the state, the subject matter of this state appeal is substantially similar to the one which we one in writ appeal number so and so between by us wide order dated so and so. First up, the operative portion of the order in the cognate appeal reads as under. First up, next paragraph. Learned counsel for the parties submit and we agree that the like cases should be decided alike, subject to all just exceptions, into which category the argued case at the bar does not fit. First up, next paragraph. In the above circumstances, this appeal is also disposed of in terms of the cognate matter. Yes. That copy you have to say, you have to tell Ponda to give one copy.
You ask all the secretaries come. There are computer is very. Whatever computer is there, you can search it.
The rule is amended. Therefore, relief in terms of amended rule is given. Just mind that paragraph. Same paragraph is produced and disposed. Yes. Yes. Structure that judgment that way. Yes.
This rate of bill before the English of judgment written
23.
The state appeal before the English of judgment written 25th June of 2024.
You are the appellant.
Yes, ma'am.
Yeah.
By the annex 1.
What the
confirming the punishment passed by the discipline as well as the appellate authority.
What was the punishment?
That is, can see annex 6 minutes.
I can see, 61. But you can tell also.
Yes,
what is the punishment? What was the culpability?
Yes,
misconduct, and what is the punishment? Yes.
Page 34, the focus notice.
We are not on that. Our question is simple. What was the misconduct? What is the punishment?
My lord, the allegation was that on February illegally, he has passed certain documents for sanctioning of loan.
Illegal sanctioning of loans and thereby causing loss to the bank.
That is not quantified also.
That need not be quantified. Yes, but illegal grant of loan is obviously loss to the bank, your employer.
This is the major allegation. And there are also several allegations, minor allegations. Now, can you see the findings of the inquiry? It clearly says
what allegation is proved, what allegation is not proved.
There are total 10 charges.
Correct.
Out of 10, 8 charges were proved.
8 are proved.
2 are exonerated.
And the competent authority accepted the inquiry report.
Yes, ma'am.
You were given proposal notice.
Yes, ma'am.
You gave that representation to
everything.
Then the disciplinary authority passed the order of punishment of dismissal.
Yes.
Dismissal is affirmed in departmental appeal.
Departmental.
And by the learned single judge of this court.
Also, it is confirmed. Without giving any assigning any reason.
What reason?
I will come to that.
Yeah.
The grants I have taken.
Very well. How many years of service you have put in?
He was almost 32 years.
32 years.
Yes.
At any time were you subjected to disciplinary inquiry?
No, my lords.
All service records clear?
Yes, my lords. Even I have been recognized for my work at the bank several times. I have been appreciated by the bank authorities.
How many years of service left over?
It's around 10 to 11 years old.
10 to 11 years. How can that be?
He was dismissed in 2007.
2007?
Yes, my lords. So another 6 to 7 years, I am not sure about that one.
It cannot be 6 to 7 years. Because below 21, nobody be appointed in the bank. And he has put in 32 years.
Another 10 years, I guess. I'm not sure.
Maybe anything. We will see that. Very good. Suppose when all the three persons concurrently passed orders against you, this is intra-court appeal.
Yes, madam.
What business we have to interfere with that?
I've taken those grounds based on the decision of the Honorable Supreme Court.
What is the decision?
First ground I have taken.
What is the proposition?
That there is no speaking order passed by the learned single judge.
No speaking order by the judge?
And see wide annex 1. I have done that order. At page 24.
Page 24.
Paragraph 7. And all those para 1 to 6 are almost factual aspect of the matter. In para 7, further, the High Court is generally very conservative in interfering with the departmental proceedings unless there is a blatant violation of the principles of natural justice or gross procedural irregularities.
Number one, we will rectify you now first.
Yes.
You have put in only 29 years of service, not 32 years. There is a finding. Do not say something which is alien to the records. Because we go by your version, or because we have no reason to doubt the bar. We believe that bar is punctual. Bar does not mislead us. Come to page 31, Roman paragraph 3.
Yes, ma'am. Page 31, ma'am.
Yes. Running page 31. Roman paragraph 3, English paragraphs 4 and 5, 6 and 7.
Yes, madam.
All their reasoning part only. How much reason the judge should give?
Madam, this is actually these.
Speaking order judge should make is true, but he need not make a loud speaking order.
Because no relevant case laws are discussed actually.
No, unless you show.
Yes, I'll show them, madam. This is the first ground I have taken. There is no speaking order.
What is the proposition? Your proposition? No speaking order.
Yes,
madam. Apex, what I tell one case to you. I should tell you what is speaking order. In Mysore, what happened was the excise commissioner rejected the application for grant of liquor shop, license for liquor shop, saying that Mysore is the cultural capital of Karnataka and it is not appropriate to add one more arak shop to the existing lot. Only one line. Matter went to Apex Court. Argument was, this is not a speaking order. Kindly see that Commissioner has passed only one line order. Apex Court silenced Dabdhari, C.K. Dabdhari, saying a speaking order need not have tons of reasons. A one single sentence can be a speaking order. Although Shakespeare said, one swallow makes not the summer. That is not applicable to proceedings here.
Well, I'll accept that. The first ground, I left that. Now come to the second ground. Now, Ground number third, the third ground.
Third ground.
For that, the court failed to recognize that the entire inquiry and the punishment passed based on no evidence at all. Now, there are some authority who says if the finding is based on no evidence at all, a certiorari can be issued. The court can be checked that. Now, can you see the findings of the inquiry officer, my lords?
Yes. Where is the inquiry?
I'm giving them. Page 61, my lords.
61.
Yes, ma'am.
Annexure 6.
Yes, ma'am.
Page 23. I'm sorry, 53. Internal phase 2. DR's presentation.
Yes, ma'am.
Findings.
Yes, ma'am. It's clearly
We're referring to writ appeal.
ma'am, sorry, 47, page 47. That is your the findings, my lords. Annex of 4. Use finding. 47. This is related to the first charge.
No, start with the DR's presentation. That since we're going into the facts, just use finding above DR's presentation.
Yes, ma'am. DR, while cross-examining the
Go slow.
Here,
Going ahead, leaving us behind.
DR file cross-examining the MW1, examining DW1, DWT2, placed on record that Sri B.K. Mohanty had neither processed the loan application forms, nor recommended the same, as there was no handwriting and signature of Sri B.K. Mohanty on the application form. Hence, Sri Mohanty is not guilty of the irregularities. This is the presentation. Now, the US finding is the next paragraph.
That is presentation. That is the submission.
Yes, my lords.
Not finding.
That is not the
Yes,
finding.
sir, finding is next paragraph.
Yes, my lords. No document showing processing and recommending the loan proposal by Sri B.K. Mohanty was produced.
So
Where are you?
you have not got the correct page.
We are not on the same page.
Same page.
It is said, no? We are not on the same page.
Page 47.
Page 47. No, metaphorically, I was here. He was findings.
Yes, my lords. No document showing processing and recommendation the loan proposal by Sri B.K. Mohanty was produced. The form A117 in all executed cases were not filled up properly as a result of the land holdings were not mentioned to justify the limit of loan sanction. The loan application forms except Upendra Naik, which was filled up by Sri Mohanty with a noting under refinance paid and of Ratnakar Behera, partly filled up, were not carrying any signature and handwriting of Sri B.K. Mohanty. So there is no approval from Mr. B.K. Mohanty. So he is not responsible. The loans were given at a loan fair, which was handed over by the branch manager. So the finding is that neither he has processed anything, not any document were produced to support this claim that he has processed those documents. So it clearly shows in consonance which is required.
Where was where that contention was taken up in departmental appeal?
That is by the annex of 3, my lords.
That will show that contention in the appeal.
Yes.
Where is your appeal memo?
Page 38, my lords.
38.
Annex of 3. Paragraph 1. Page 38, Annex of 3.
Where is that contention?
Regarding the processing and recommending the crop loan, SCC, I am the person who would like to follow the norms and the guidelines. The loans were not processed by me before the sanction. The branch manager was sanctioning the loan on the face of the blank documents. It was then placed on my table, either by him or by his broker to fill it up only. I had got no voice in sanctioning the amount. This is in para 1.
You have no voice in sanctioning the loan?
Yes, my lords. Because there was a...
Where is your job chart? What are the jobs you do in the bank?
There is a loan fair in the village. So these loans are actually given by the branch manager. I have no role to play. That was my contention.
Who are you?
Assistant manager.
Assistant manager.
Yes, manager.
No, you show me the loans are sanctioned not by you.
Not by me. Even my signature and my recommendation not there. That is the finding of the EO.
That is in respect of one charge.
Yes, Milord.
What are the other
This
charges?
is the major charge.
That's the major.
This is the major charge. Even the loss is not quantified. Even my
Loss is not quantified already. In Latin maxim, Broome's legal maxim, there is a famous book. He quotes one maxim. What is not ascertainable is certain. If you can ascertain, law treats it as certain.
Yes.
Therefore, that contention will not help you.
Well, that will help me later because I find one judgment from the apex court which says if the gratuity is forfeited but no loss is quantified, then
that is different case.
And in this case, my gratuity was stopped. That was not a part of the punishment also. So it is automatically stopped. Even there are several judgments.
You can't forfeit the gratuity.
Yes, Ministers.
Because your contribution is also there.
Yes, Ministers. So the loss, quantification loss is mandatory before forfeiting the gratuity. So that was not held in my case.
Here recovery is not ordered.
Nothing is recovered.
That was a case relating to recovery.
Those accounts are not MPA. Again, after a few months, they are again sanctioned loan.
To those borrowers only.
Yes. This is a part of record in the bank.
You glossed over that. It was a refinance 17,000, which was, it is refinancing of the loan actually.
This was,
I mean, that is in your favor. You should have also.
Yes, ma'am.
The
That was not
signature that were found, one was for refinancing a loan.
Yes, ma'am.
Refinancing, restructuring, banking law, tendon on banking law says, where loan is restructured, the bona fide of the loanee is prima facie established.
But this part of verifying the documents, land pattas,
yes, ma'am,
was your job?
That is my job. But when I was presented to fill up some 250 forms,
you have not
denied that.
You have not signed them.
No, not signed.
He refused to. He was given plans to fill up.
He refused to.
The reason given that he was
But that fact you did not place while now placing.
No, it is there, my lords.
No. There and you arguing in the court are two different, altogether different things.
Yes, my lords.
We may be reading the file, but you have to make a sequential argument.
No, it was before the learned single judge, but those facts were not considered. That was my point. Even there are
if a loan is sanctioned in loan mail where he is not there, how can he be held responsible? You were not subjected to any disciplinary inquiry in 29 years.
No, there was a disciplinary inquiry.
Earlier also?
Not earlier.
Not earlier.
No, man.
This is the first disciplinary inquiry.
Yes. Even I have been appreciated 2 or 3 times for my good performance. Yes. This was also mentioned in the order sheet.
Let us see. The issue, emergent notice. First off, appellant, in addition to taking usual steps towards process, shall serve a copy of the appeal memo along with all the documents from the learned counsel who represented the respondent back before the learned single judge. Immediately. Let us see. We'll issue notice. You have made out a case now.
My lord, there is a delay of 14 days.
Let us see. We have to hear him, then we can delay. Since you notice on both appeal and appeal is both. Actually, it should be on both. I do not know why. So yesterday I went through rules also. It has to be on both. Yeah. Yes, sir. Yes, sir.
Before a delay of 53 days.
53 days. What is on merits?
It's my lord, I will address your lordship tomorrow or
Call week after next request of counsel for
44 days. Reported is 42. So go by that.
He wants time.
Yes.
2 weeks. Yes. Yes, sir.
Petitioners find this writ appeal challenging the Honorable Single Judge on the ground that I have filed earlier writ application 2015 and some self order are there. For that only some self there cannot make twice. For that only writ has been dismissed.
What can't is delay? Applies to read proceedings also. Section 11 of CPC. Section 11 of CPC incorporates limited idea of res judicata. But Apex Court says whether Section 11 is applicable or not to all civil proceedings. And writ proceedings may be civil or criminal.
Even if writ petition
applies.
64 Supreme Court.
64 Supreme Court.
So that only I have given that second writ application is applicable. In this Honorable Court judgment in 6th January 2000.
You argue the best part. Are you disputing that it was the same cause and same prayer?
No, this is not. I am not disputing that part. But at that time,
then how can it be? If you yourself you are confident, I mean, you are sure that it is the same cause of action and same prayer.
The same cause of action at that time. The Supreme Court. I have annexed that on the.
Or it is a continuing cause of action.
It is a continuing cause of action.
What was it? Why you were for the first time? Why you were before the court?
First time I was at 1997. I was before this Honorable Court.
What was your prayer?
That was prayer that my appointment should be approved from the 1/6/1994 as my school was approved from 1/6/1994. Then this Honorable Court passed the order that
This court, single judge said no.
No, division bench.
Division bench said no.
Yes, Lordship. Lordship have a glance to the
page number 24.
Lordship, in the rate appeal, Lordship, I have quoted that.
That is page 70.
Yeah?
No, sir, that one.
What was the prayer then? And what was the foundational fact matrix on which prayer was coined? What is the prayer now? And the corresponding fact matrix.
In the impugned order, prayer has been quoted, earlier prayer.
In the impugned order, page number?
Page number 17.
17.
Paragraph 6 said that
how can you say that it is the self-same issue? It was your contention before the learned single judge.
Yes.
Show that it is, you have to demonstrate, res judicata, estoppel. You have to demonstrate if you take up those pleas. That's the law. Identical cause of action.
And you did not file affidavit or counter.
In that writ petition, I have not filed.
Here, see, before the learned
single judge, not filed.
Even though notice of the writ petition has been issued, but no counter affidavit has been filed.
And Apex Court said in the very 64 Supreme Court, another judgment, the plea of estoppel, the plea of res judicata, coupled with evidentiary material, has to be taken up before the court so that he will be able to answer it. It cannot be taken up off-handed just by argument.
Annexal 7, page 36, they are writ petitions.
Page 36.
And WPC now 2407522.
Page 36.
7 is not there, it ends with 5. In 9 brief.
Page 37, Annexal 7 series.
Page 36.
Page 38.
38.
Read copy original.
It is with the people I have had.
He has filed that. Annexer 7 series.
No, I have a copy of the writ itself, but it ends at.
Prayer portion is internal page 8 of that writ petitions and page 38.
My brief ends at 20 rather. 20. Postal list is 20.
The earlier writ petition at page 38.
Page 38.
Another patient whereby in prayer. Kindly see the prayers which he had made in the earlier petition. Copy of the prayer column is available. Yes. Whole petition is available.
The same prayer is quoted in the annex of
It is
the
the petition prayer.
Yes.
Oh, yes, I am having that. You said, I thought that you are referring to writ petition page 30.
No.
No, where is the identity? How are you going to decide whether doctrine of res judicata is applicable?
Have you seen I thought you are referring to the earlier writ petition and the prayer.
Right. I'll show that.
I think it is not there in the record actually. Even to go that far is not possible.
No, without producing the material to show that there is identity of cause of action, causes of action, and the same fact matrix or substantially similar fact matrix.
Right.
Earlier legal battle was what? And it ended. Now you cannot relitigate, which in Gautama Sutra, in Hindu law, Purna Nirnaya Siddhanta, Purva Nirnaya Siddhanta. Earlier already, res judicata, already it is decided. He could have made, but he did, he omitted to do.
But 11.4 is might or ought raised. That is constructive.
Constructive res judicata, not res judicata, constructive. But even that, perhaps the learned single judge was with hurrying.
There is the order bloods that is.
You made him to hurry more.
Page 44, you will see that
16.
46. That is the writ dispose of.
6.
The grievance of the petitioner, though he is working as real.
Just give us a moment.
Release the arrears of salary of the petitioner for the period from 1/3/1999 to 17/12/2000. What this whether time runs in negative? 2009. Okay, you are right. 1/3/1999 to 17/12/2009 within a stipulated period.
Here is a case, Millers. Here
that was release of salary.
Yes. Arrears salary.
Arrears of salary.
Millers, here is the case that case that he was appointed as a peon in 1991. Fourth peon.
No, fact we need not go because there is no factual adjudication.
There is no
we may ultimately that's another thing, but right now we are grappling with some other issues.
So where is the identity of cause? How are you going to know
the copy of the writ petition, earlier writ petition, because
where is your prayer?
He is filed writ appeal, but
no, he is filed writ appeal because he is aggrieved by the order.
Yes, let him file. He has filed the earlier.
No, you should say. You should show.
I'll show Millard, let him supply the copy because it's
actually it is your stand. The problem is that before the learned
filing the objections,
the learned secretary has recorded your stand, not his stand.
Right. I'll start with that writ petition. If not so wide.
That's a petition.
This is in order to consider this.
That they are not considered. That they should say. Earlier, brother, there was a direction to consider his representation for payment of 10-year arrears of salary. It went in his favor.
Right.
You did not consider. Therefore, again, he is here.
And he is correct.
He says
he was not arguing. It's a continuing cause of action.
Continuing cause
of action. Because beyond...
I'll file objection to that writ appeal, whether that representation was considered or not.
No, that's factual again. That you should have done there in the writ petition.
We'll allow this writ appeal.
No, let me check.
And remind the matter to the learned single judge Let him decide where you can take up the contention.
I'll file counter there. Liberty may be granted no file objection. That,
Rather, we are granting you that before, and we are telling you that you whatever stand you take, you take.
My lord. Okay. The
41 days delay may be
respondent,
counted. 41 days delay.
application supported by affidavit seeking condonation of delay is favored for the reasons stated therein. First of all. There- The respondent employee was before the learned single judge in WP number, which is the present WP number.
Present WP number is 24075.
So, grieving against non-payment of arrears of salary for the subject period of about 10 years or so. First off. On notice, learned AGA appearing for the respondent resisted the writ petition, contending that the second writ petition was barred by doctrine of res judicata. Inasmuch as petitioner had litigated on the very same cause of action earlier in WP number, which is that WP number 8082 of 2015. Disposed of on 1/5/2015 with a direction to consider the claim of the petitioner. First, learned single judge was swayed away by this submission and declined indulgence in the matter. First, that is how this writ appeal has been placed at our hands for consideration. First, next paragraph. Learned counsel for the appellant rightly submits that non-payment of arrears of salary in an employment like this would involve ordinarily a continuing cause of action, and that semicolon. Secondly, in the earlier round of legal battle, a direction was issued to the opponents herein to consider the claim. However, the claim remained unconsidered all through. First off. Therefore, learned counsel submits, the impugned judgment of the learned single judge is unsustainable, there being no substratum, legal or factual, for the invocation of the doctrine. First, learned AGA per contra submitted that there is res judicata. Sorry, the case of the appellant is liable to be res judicated because of the earlier round of litigation. First off, we do not subscribe to that view. Arrears of salary are not just debt owed to the employee, and they are more than that. First off, there is some scope for the argument that the arrears of salary constitute property guaranteed under Article 300 capital A of the Constitution, when the opposing parties are Article 12 entity. 12 entity. First, do you remember that judgment? The arrears of salary in public employment is a property.
Yes.
Which is the judgment. Just keep that.
Yes,
Can anybody find out that judgment? Arrears of salary or a property under 300 capital A.
Not entitled to.
Yeah.
Go on line Millers.
Okay. On that line, this one. Just
Not entitled to salary.
Area salary Millers.
No. Apex court say.
No, that comes a res judicata on you. Because on the earlier occasion, you are not your stand that, but you tolerated order which asked you to consider.
You suffered an order.
Right.
So I was thinking that it's a both. It can be argued both ways. Now you will argue that this is res judicata.
Cannot. Next paragraph.
At this stage, you cannot.
It has been settled position of law that the doctrine of res judicata or estoppel by a record is invocable provided that such a plea is taken up in the pleadings supported by legal evidentiary material, which is lacking in this case. First off, we say, we repeat that the learned single judge was swayed away by the submission of the opposite parties, and that has resulted into prejudice to the appellant hearing. It hardly needs to be stated that even at the first round of litigation, matter was not heard on merits. What was granted was an order to pass order on the claim of the appellant hearing. First up. Next paragraph. In the above circumstances, this appeal succeeds in part. Semicolon. The impugned order of the learned single judge having been set at naught, matter is remitted to the portals of the
postal beach for consideration of
Liberty may be granted. Liberty may be granted to file objection.
Consideration of fresh. First off, liberty is reserved to the respondent to file their pleadings, if any, within 4 weeks, failing which right to file one would stand forfeited. First off, will impose cost now. He's a poor employee. He came and said, my payment is not made, salary is not paid.
In fact, he is not entitled on merit.
No, we do not know. You should have decided it on merit. Why did you mislead the learned single judge? You need to come in early here. No, cost has to be.
You look at the earlier order, then you submit this.
I have seen that.
Your substratum has falls flat on its face.
Yeah,
you pay 20,000 rupees cost. How much? Then you tell.
He is getting salary.
No, the question is not that. You should have said you are not entitled to arrears. That you did not say.
You will challenge it. That's another thing, or cannot accept it. That's another
You
thing.
cannot sleep over the right of
I remind the matter. I love it. Lot targeted the matter, so that's
4 weeks. 4 weeks. You file your reply within 4 weeks.
4 weeks and they targeted the matter to the.
No. You have to pay. You cannot harass the citizen that way. The citizen is not the slave of this country. He is an employee.
There is no instruction.
This is a case for imposition of costs. And in our considered view, a cost of rupees 10,000 to be paid by the respondents to the account of petitioner, the appellant hearing within a period of 4 weeks.
4 weeks, a little bit.
Why is it? Government is so poor.
I'll communicate the order.
No. Feeling which
within 1
till 50 rupees per day in addition. This amount may be covered from the officials.
I pray that within 1 month, because of I'll communicate that.
You will get the order today. You can't harass the citizen that way. At least government will be alerted by this. You can't take for the citizen for granted. Yes, sir.
was received against punishment imposed against me. I was the registrar of court. And the charge was against me, saying that while handing over some documents I have handed over to the Honorable Chief Justice, and while I took back and wrote some of the documents.
Can you have a mic facility there? Can you avail it?
Just bit on that left hand side.
Yes, sir.
I handed over some documents to the Honorable Chief Justice when in connection with the promotion of some of the employees, and took back the documents, and while returning some of the papers, a part of the file was not returned to me back. That was kept there. And subsequently it could be detected that some of the papers were missing from the file. A charge was framed against me saying that the papers were missing.
Promotion related to promotion of the employee.
Population of some of the employees of the.
Anybody competed with you, or did you compete with anybody within the zone of consideration?
Not
his promotion.
I am the registrar of this Honorable Court. In connection with some of the employees' promotion, some file was called for. I have handed over the file to the Honorable Chief Justice, then Chief Justice. And some papers, while I took back the file, some papers were missing.
Missing means they were retained in the office of the Honorable.
They were retained with the Honorable Chief Justice only. It was not returned to. And I didn't have the courage to ask what happened to those papers. And subsequently, a charge was framed against me, saying that the papers are missing from the file.
When you originally produced, at that time only they were missing.
I have produced it. I did not take it back.
No, you produced the file. Whether these papers were missing when they were produced by you, or they were missing when they were sought to be returned to you.
When they were returned to. When they were returned to me, my plea
What is asking at what stage you detected or it was detected?
It was written.
The file was returned to you, then you kept it?
Kept it in the file. Kept it in the office.
You kept it in the office?
Office.
The detection is post you keeping it in the office?
After I was transferred, then this was detected and I was called upon to explain what happened to those part files.
If you took up the contention that all papers I had given, but when returned, they were returned to your successor in office.
No, to
you only.
To me only.
How many pages they are?
They are.
Entire file consists of how many pages?
Entire file has been returned, except in few papers.
No, therefore we want to know totally how many pages is comprised of?
That pages 116 to 152.
116 to 152.
Yes. That is from the part C file, correspondence file.
36 pages.
36 pages. They are the documents which are relating to the different employees, who
were aspiring for promotion.
And
because of that, they were not given promotion. Any consequence happened?
Nobody was prejudiced by that. That is only copies. That is the part C file. Most part C file only correspondence matters and only copies. Original files in the respect to employees' records, personal records, that's there. I have only given the copies.
What is the punishment?
So far I am concerned, the punishment given to me was two increments were stopped, Mira.
With cumulative or non-cumulative? Cumulative. If it's cumulative, it's a cumulative effect. Cumulative effect, if it is with cumulative effect, does it amount to major penalty? What do your service rules say?
That is a major penalty.
Which under which rule?
Under the CCS rules.
Kindly read.
Rule 13 of the CCA rules.
Nature of penalties. Withholding for increments without cumulative effect is minor.
When sufficient reasons as they are here not provided to impose on the government servant, namely 6A, withholding of increments.
Without cumulative effect.
Yes.
Where? No, these are the classes of punishment.
Yes.
Your rule 15.
Rule 15 is major penalties.
Procedure 14. No, which rule says withholding of so even that is also major penalty. In Karnataka, if increments are withheld, 2 increments are withheld without cumulative effect, it is not a major penalty. It's a minor penalty. Anyway, here it becomes major recovery.
That's fixing if the appropriation mistake. Especially both places it is without it. Here again without.
One should be with at least this one. Second one, because above is ensured, all minor penalty. Withholding of increments with cumulative effect should have this Why we are asking this question is the apex court said in one judgment, Justice Kuntwalia said, in matters of court disciplinary proceeding, if minor penalty is imposed, generally that will not be interfered with by the writ court. Therefore, our question is linked with your right to relief. But my brother is now showing there is duplication. There appears to be there is a duplication actually. You are seeing that Rule 13, 3A, Roman 3, capital A. Small Roman 3, capital A.
Yes, withholding of.
Withholding of, withholding of
Roman 3, sir.
3.
Roman 3.
Withholding of increments without cumulative effect. Now come to Roman 6, capital A. There appears to be mistake. Withholding of increments without cumulative. It ought to have been with cumulative effect.
Yes.
So just is it just Mudra Rakshasa print mistake or mistake of very draftsman himself? That we have to see.
Must be printed.
Because your right to relief is linked to the quantum of nature of penalty. If penalty is major, our potential to interfere is higher. If it is a minor penalty, Justice Kuntwalia has laid down what are the parameters. Just kindly look into and come back. There are other judgments also. which Justice Ramajais discusses in his services under the state.
In your book, the same mistake or
it's the same print. It is
They are all whole.
Just we are asking you, will you be satisfied if one increment is withheld? We are asking, we do not know. Even if you say yes, it is not that we are going to do that. We want to ascertain.
Let me place the matter, you will also be convinced that absolutely no case is made out of this. That's the registrar of the court and Honorable Chief Justice wants some records to be given. I give it.
Who is the custodian of the records in your rules? You are. Is it you are only figurative head of the custody?
Yes, figurative, naturally.
What was your stand?
When they issued notice saying that certain papers are missing in our file.
I said this, all the facts are admitted. I said, yes, I have handed over the file to the Honorable Chief Justice when they wanted and took it back and I found that some papers are missing, but I couldn't dare to ask him.
No, not asking the Chief Justice, but there are many. The Honorable Chief Justice is assisted by a host of employees. You could have asked his PS. You could have asked his additional PS, saying that, sir, in fact, when I gave the file, all papers were there. But when it was returned to me, some papers are missing. You could have said it apologetic voice. You would not have raised your voice and hand is true. And you will not be having access to the Chief Justice. But you will be having access to the office of the Chief Justice, wherein even there is a peon also. You could have called the peon and said, convey this to your additional registrar, additional PS.
But the facts would show, but this is such a sensitive issue. Honorable Chief Justice personally took it and kept it with him.
What you would benefit by it?
Because some members, some of the staff were given promotion earlier and that is reversed. So such a situation was there. Therefore, the Honorable Chief Justice wanted the registrar to bring the papers personally and it out. He wanted to examine.
But this stand we did not take before the...
I did not take...
You could not take, brother.
No, I did not take the stand that I have made inquiries through other staff. Certainly not because...
of the highness of the office.
Highness of the office and some amount of secrecy has to be maintained. I had handed over.
Then we'll issue notice.
No, notice was issued, my lord. Pleadings are complete. I have filed... they have filed counter. I have also filed rejoinder. Now the person will only fix up a date for...
What do you say? Only this much only. What is that arguing? There is nothing. It's not like Keshwananda. What do you say?
Let's see that inquiry report.
Page number?
Page number 68. It's a start from 67. Page 68.
No, assuming that this... we are again just putting it across because we had put that question to him. We are putting that question to you also. What is the loss occasioned by this culpable conduct? He is the figurative head of the custody department. Many hands operate there. And he has taken a particular stand. How I am going to be benefited by this? But that he cannot so easily say. Everybody will say tomorrow same thing. Custodian is bound to maintain the custody.
Another allegation is the ineligible person has got promotion by virtue of that.
But that is set right now.
Yes. That is by virtue of the recommendation of that.
That is set right.
Yes.
That is a mistake rectified. It is not that somebody got promotion and he remained there and retired in the said post. Not like that.
Not.
That is rectified also. Mistakes do occur in any human institution. That is the reason why review. Order 47, Rule 1, 2, you have seen how the text of law is.
Inquiry report, Millard, all the charges is well proved, Millard.
What are all the charges?
Charges means dereliction of duty, administrative indiscipline, and
all that they are on the same bedrock only.
And failure to maintain absolute integrity and honesty.
Integrity and honesty.
Yes.
Integrity, honesty also it is related.
Yes.
He wanted to benefit a particular person with information when he was not entitled
One is
to.
gross misconduct. Second is Miller's dereliction of duty. Third is administrative indiscipline while dealing with the administrative records. And four is failure to maintain absolute integrity and honesty. That is
What were
all.
the charges you had leveled against him? What were the charges?
That is the charges, Miller.
So the charges. These are the charges.
These are the charges.
All the four are proved.
Proved, Millers.
How many witnesses have been examined?
That's
And who are
only one.
one witness?
Yes.
Who he is?
That is a deputy registrar, I think.
Registrar.
Suman Patnaik, Suman Misra, deputy registrars. Yeah.
Here is examined.
Yes, Millers. That is Miller's department. Suman Kumar, register judicial.
Registrar Judicial.
Yes.
What is his deposition? Let us see.
Imposition copy, I don't have.
Do you have deposition copy?
Yes. No.
Yes, just shows.
Ah. 7.
And he had sought for a personal audience with Honorable Chief Justice. Whether that facility was given to him? Kindly come to page 66.
It is.
Para 8.
So,
Yes.
With folded hands I pray.
Bharti, since you are arguing it now, the way you, was it your case that he has, so who was benefited by his act? Because the stand is very clear. Mr. Rao also said that the missing documents have not resulted in any administrative inconvenience as far as the administration of this court is concerned. He told the
One promotion.
So, that stoppage of one increment without cumulative effect.
See, because you admitted the guilt.
No,
They were missing is admitted.
missing is fact is admitted.
Yes.
Not the guilt.
What else is necessary? Admitted fact need not be proved. Section 58 is applicable
understand.
even to such cases.
My submission will be admission of a fact is not, because I can't controvert those facts which are on record and.
Otherwise also that fact remains demonstrated.
Yes, because it's a fact that I have handed over the papers. It's a fact that I have taken back the.
Therefore, that cannot be.
I can't say anything further, except saying that I have no courage of asking the Honorable Chief Justice to come back.
No, you had the courage of asking the audience. You had asked for personal audience with the Chief Justice.
That's right. But the.
Okay, why that was not given? At least Honorable Chief Justice would have said, you can't have access to me because I'm overburdened. I will tell you one thing. You go to my additional PS, you speak to him. It is not that office of the Chief Justice is an impregnable China fort.
That is
accessible.
That is a practical difficulty.
You should have said, the Honorable Chief Justice should have said, I will not hear you. Brother, I'm overburdened. But what I will do is, I will ask my deputy to give him personal audience.
That is happens sometimes, Millers.
At what time it happened? At what period it happened? It is not that
Your Lordship,
the
see
Chief
that
Justice does not mean.
68, that Your Lordship, it is clear that there is 68 paragraph 2. During the incumbency of the delinquent officer as the registered judicial of the High Court of Orissa, you are the custodian of administrative files such and such of appointment sections of the High Court relating to the promotion of secretaries, class 2 to AR come senior secretaries and class 1 to junior from May 20.
Just give us a moment, Mr. Kumar.
Yes.
Information. As on the day, the committee met, he was not there at all. Or then you can. Can you just because of missing papers, some ineligible person got the promotion.
Yes, that cannot be. Some ineligible person might have got the promotion. It may be true, but not because of him, because the committee met on 23/12/2019. The promotion committee held the deliberation on 23/12/2019, and he came to the office on 13 January 2020. He was not there at all.
And that person was less.
But how he is responsible for it?
Because at the relevant time, he was the custodian.
Can we take the remoteness of damage to that level? Then we have to say, since Adam and Eve ate the apple, all these things happened. Had they not eaten the apple in the Eden garden, nobody would have taken birth. All these things would not have happened at all. Can we take that to the point of Big Bang, where universe took birth? Had universe not taken birth, all these things would not have happened at all. The Salmon discusses two cases, Vagamond 1, Vagamond 2, doctrine of remoteness of damage. You can't, there's a very famous book on one, Tony Honor, H.L.A. Hart and Tony Honor, they have written the causation in the law, where it has to stop. The cause has to stop somewhere.
Let's keep it some other date. I'll bring the entire file that display.
We have heard now.
Because I'll
and though you are submitting, but is there any finding also?
Because of this, because of
inquiry officer gave a clear finding.
Where is that finding?
Okay.
Inquiry officer.
The dates also.
Let's date has been mentioned.
Check that. Then there is some mistake. You point out where in the inquiry report the dates are given.
No official of the court, nobody should go with the heartburn that because some higher functionary is involved, I could not get justice. That should never lurk in the lower rung of the employees.
Page 68 para Roman 2, 21 to 2020, 6 to 2020 and 6/3/2020, he placed the aforesaid file before the Honorable Acting Chief Justice.
Yes. That is not what your argument. Your argument would be, or maybe you are arguing that because of non-production of those files, the promotion was given in a way which could not have been given.
Right.
So date of promotion, are you aware of date of promotion?
No, that
is 24 December 2019.
That is in para 7 years.
It's only meeting of the 24. What if it? No, when the file was given to the when the file was given back to the delinquent, which date? On which date it was given to you back? Just
That is in August 2020.
August 2020.
20.
But by that time, 23/12/2019, DPC had met.
In 20, you got back the file.
Yes.
This is from the office of the Honorable Chief Justice.
No, wait, one small thing.
February 2020.
1 second. Is it the specific case that when you handed the file to the office of the Honorable the Chief Justice, the file had missing papers? Or file was complete. Thereafter, when it was handed back to you, at that time these papers were missing.
Yes.
When the papers were reached back when?
So which is the attribution? First one or the second one?
Second one. Which one?
Second time.
Second
when
one.
I got back the papers, file was not there.
Brother, if second version is true and correct, so far as missing file has to be admitted, as we admit missing link in human evolutionary biology, like missing files admitted, otherwise also demonstrated. But consequence because
when it was missing,
that is not linkable to the delinquency. Where is the link? Where is the nexus between the delinquency and the occasioning of a promotion committee holding the proceedings? Promotion committee met in
Monday, Millers, I'll bring that file of Millers. I'll find out the link for and what time file was missing. That is the questions. Whether at the time of produce before the Honorable Chief Justice or return back.
We have it tomorrow only, because we should not forget by the time you find out the missing link, we may miss all that we have heard.
The difficulty would be, suppose you proceed in one way while arguing the matter, and the attribution is different. So it will be going against your case. So that is how, in fact, we are also grappling with that thing. What you are saying and what emanates from the
file,
there is a deposition and the file, and so there is complete divergence.
Deposition is separate, proceeding is separate.
Yes, you as a lawyer, you built up your case in with whatever dimension you want. But that should be
basis of papers. And don't be under the impression that merely because it is office of the Chief Justice that an employee can go hurt that way. We don't subscribe to that way. When murderers are given clemency petition to present right to maintain clemency petition, writs are issued against presidents, against governors to consider. Satwan Singh versus Delhi administration, state, 91 Supreme Court. It was issued to the President R. Venkatraman saying that the mercy petition is deemed to be pending before him and therefore it should be disposed of. If that is the case, if that is the response which the court in judicial side will show, the same has to be the response, even if Chief Justice office is involved. We all work under rule of law. Nobody is above law.
This is what the Vasishtha and Vamadeva were told when Rama declared
in his coronation, I am the emperor, nobody will be above me. Then Vasishtha had patted his head with Dharmadanda, saying that Dharma is above you. Similar is the case here.
And you don't end up injuring your case further. That is the concern. The problem is the more you divert from the issue,
more defense will be strengthened.
They will
appears two increments with cumulative effect appears to be
major penalty.
Appears to be no, they are major penalty. That's only a printing mistake. Therefore, I called it
cumulative. I have got that with cumulative. That is
it's a cumulative effect. This is cumulative.
With cumulative.
We are getting the gazette actually.
No, I have already.
Otherwise, you will be worse off because you cannot impose that penalty at all.
Telling the with cumulative effect.
No. Otherwise, you will be worse off in the defense. The prescribed penalty alone can be imposed.
There is a decision of our High Court also. Division bench.
It's so sad.
Recent also.
Party to that also earlier. Then that you cannot
impose that increments without cumulative effect. You have to check that on the gazette.
No, that is cumulative effect. I have got that.
It has to be with cumulative
Yes.
effect. Obvious.
Withholding the increment with cumulative effect.
So the key also is the individual. For the visit of the record, this will strengthen the case of the upper further.
It was given by you, sir.
I have copy.
You have a copy.
I have a copy. Day after tomorrow.
Day after tomorrow. For extensively. First, learned AGA seeks a short accommodation to add certain points by way of clarification. First of all, call this matter a day after. Copy, provide copy. And I have to answer that question. When he specifically prayed, kindly give us an audience. That whether that was given to him or you replied at least saying that, no, we will not permit you. We want to know what Honorable Chief Justice said to his response.
Serious the charge, stricter the this allegation is serious.
He could have explained from that time what would have happened. We should use very yeah.
There is a noting that notice has not been made sufficient. However, my learned senior is appearing for the respondent number.
One I have filed with power. That is not done.
Are you ready in the matter?
I will serve a copy.
Yeah. And serve a copy.
Yes.
We'll call this matter on. But they are substantially they are similar. Different matter.
Because the advertisement, two different advertisements. But these signatures are directed to give the
No, dominus litis is there. So you please wait for that stage.
Well,
let us see.
In the second case may be treated as the lead matter where the question of law will be decided. The first matter during the course of hearing, although that was not an issue before the single judge, during hearing in the writ appeal, Honorable the Chief Justice, this matter was listed before that bench, and the Honorable the Chief Justice directed that the matters be put together because the question of law involved became.
Very well. You serve a copy now.
Yes.
On the other side. So that next date we will consider, and if necessary, we will detect or we can decide the matter also.
Well, so in the last order, your lordships have only issued notice on the question of limitation.
Then you take notice on limitation and on main matter also.
Yes, ma'am. Yes.
How much delay?
65 days.
Yes, Mr. Patnaik, Mr. Das.
65 days. Copy you give.
For professional purpose, you serve.
You serve copy.
By tomorrow, I'll serve copy.
Call this matter on 17th.
In the first matter, there is an
interim order. In the first matter, to be continued.
2542, Mr. Das, you have filed your power already.
Filed power only.
2542, writ appeal.
Well, it's in the second
Mr.
matter.
Das, the learned counsel, submits that he has instructions to appear on behalf of the respondent.
Only one.
Respondent one. R1.
Not in that writ appeal also. I have entered appearance on behalf of respondent number 9 and 11.
So you have been served with copy?
No, only the limitation copy.
So you served with copy. Mr. Arnav Behra for the appellate, Mr.
And I have entered
SN Das, yes, your name is there. That is how I was asked. SN Das for the respondent 9 and 11.
9 and 11. And I have instruction to appeal for Lord.
You should have made it 10 and 11. 9 11 is not a motion.
From 5 to 22. Pro forma the respondents.
You appear 5 to 22 as well. Yes.
9 11, 5 to 22. So that's, he has already filed his Wakalatnama.
Lord, I stand corrected. 9 to 20. 9 to 20.
9 to 20.
9 DO to 22. Vice.
One more point. There is one writ appeal 1868 of 2024 which has come with this matter. That matter may be listed along with these matters.
Tag writ appeal number so and so with these matters.
It's there in the noting. The matter may be listed.
Give it a writing.
It's there in the noting.
Last line
of the note.
The counsel for the appellate shall serve copies of the appeal memo along with other annexes and IAs on the learned counsel for the appearing respondents. List on 17.
Great.
Name of Mr. Das, the registry shall verify the Wakalatnama and mention the name of Mr. Das. Appearing for the R1. First matter, I'd simply list on so and so, interim order, dated so and so, shall continue.
Yes. Yes.
Item 34, I seek time to open number 1 and 2 where today will give me instruction, will file the counter within 3 weeks. Not simply give after 3 weeks any day. In the meanwhile, will file the counter. Solve copy of the other side.
But when you were served with the notice, this is 2023 matter. Under your rules, what is the time given for filing the objections?
Yes, today I am receiving instruction. Last occasion this have been copy and extra copy I have received. Thereafter we obtain instruction. Today they have given instruction. We'll simply give the last chance and we'll pay.
Can we give time?
But sorted with you.
Call in the last week of July.
Yes.
Okay.
None of their either the PCI nor the State Council has filed the response.
You take advantage of that.
Your Lordship is correct.
You don't want to file objections? Want to file? Call this matter in the last week of July 2025 to enable parties to file their pleadings, if any, failing which right to file one stands forfeited. Next.
Bye.
Certified your Lordships, we need to prepare it in date chart. The matter has come suddenly. I was just briefed, but
Which date you want?
next week, any day.
Next week, our calendar is not that free. We'll have it in the first week of August.
In the end of
Then also in the last week of July.
Last week.
All because there is all point involved in this case.
But madam wants,
Yes, but August time is the
your sister wants some time.
Next 2 weeks we have fixed so many matters.
Other matters. Your madam may not
listening and not
last week of July.
shooting up the July calendar. Time I have missed.
Okay. One side we can have July.
Or both months.
No, both sides should be July only. It is wrong actually. It should not be next 20 for the next date, sir. You put July here, August that, sir. All right. Last week?
Last week.
At the request of both the sides, call this matter in the last week of July 2025. Next.
my lord. I have already received the Parawage comment, my lord. File counter.
You have received the Parawage comments now.
Parawage comment.
Do you have objection for giving time?
But very small point involved in this case, legal point, no fact is involved.
But let him file the objections.
These persons, they are the retired employees appointed on the ad hoc basis in the POCSO court, special courts on remuneration. That remuneration is in question. So they are also going to retire from this service.
Last week of July 2025 to enable counsel for the respondents to file their objections, if any.
Judgment for High Court employees, you were, I think, appealing retired employees remuneration.
Yes.
So will it help here?
I have not checked that, but
so you check and inform me.
But
already that point.
I have not said that, but here in this case, only that word end. I don't have to interrupt.
Let us see. That can file objections.
For this counter and all this, my friend will be ready on this point only. It can be disposed of. No question of counter here.
Very. You can't say that.
No. Once you find your objections, for me, I'm for his information. You can bring me the misunderstanding. Yeah, that is there.
Next.
21st.
21st. 21st we hope. 21st throughout I have seen this calendar. Well, 22nd. 22nd. First time.
Even not super, I am appealing for the inversion fee. I need just 2 weeks time to file counter because I have appeared on 10/6/2025. All right.
Item 42, my lord, this is government criminal appeal, my lord. I pray some time to prepare, my lord. This is a matter, my lord. Government appeal, my lord, challenging the acquittal order passed by the London Lower Court, my lord, and the offences involved, my lord, are punishable under 302 of the IPC, my lord. मतलब पेपर राइटिंग यस मालूम ना खींच ना बिल्कुल मालूम Last to give this
Mr. Sister of the
Hello.
Item 43.